under Act number 4 of 2015 where applicable. The remedy does not lie in the institution of private law or statutory proceedings for the same relief that the constitutional institution failed to give. So my finding is therefore that it is only the relevant institution, particularly SRC, which have the exclusive jurisdiction to deal with the increment of basic salary and allowances for public officers. And that since they have made their decisions are constitutional, and the only way to challenge those decisions is through the constitutional mechanism by filing the appropriate proceedings in the appropriate court. Regarding the jurisdiction arising from the consent of the parties, I don't know how to deal with this one at length, because it's straight law that a consent order, such as the one relied on in this case, cannot confer jurisdiction on a tribunal or a court which does not have jurisdiction. In the case of Essex Incorporated Congregational Church Union versus S County Council, 1963, PO cases 803, the House of Law said it is a fundamental principle that no consent can confer on a court or tribunal with limited jurisdiction, statutory jurisdiction, any power to act beyond that jurisdiction, or can stop the consenting party from subsequently maintaining that such court or tribunal had acted without jurisdiction. So, in summary, and I repeat this finding, I therefore find that it is only the relevant constitutional institution, particularly SRC, which have the exclusive jurisdiction to deal with the increment or basic salary and allowances for public officers. The court, in awarding teachers a basic salary increment of 50 to 60% and allowances, a task for which it had no institutional competence to handle, made a fundamental jurisdiction error and usurped the jurisdiction of the constitutional institutions, and the award having been made without jurisdiction is a narrative and liable to be set aside on that ground. In summary, I find that the court had no jurisdiction to award the teachers a basic salary and allowances, as it could not derive such jurisdiction from the consent order or from the Labor Relations Act or Industrial Court Act or from the Constitution. Having so found, it is not necessary to consider the procedural issues of jurisdiction on the merits of the appeal. However, from the analysis of the provisions of the Labor Relations Act and the industrial court has shown above, I would agree with the unanimous finding of the members of this court that, as a general principle, a judge of the industrial court has no jurisdiction to conduct conciliation or mediation proceedings under Section 15 of the Industrial Court Act, as read with Article 159(2) of the Constitution. Regarding the cause of the appeal, I find that no party is to blame, for it is the erroneous assumption of jurisdiction by the court which led the parties to participate in the proceedings. This is a case where no orders as to cause should be made, and I would therefore allow the appeal with no orders to cause. I've had the advantage of reading the judgments of the other members of the court. There is unanimous findings as follows. With regard to the application to deny a right of audience for contempt of court, TSC has a right to be heard in these appeals. Had a right to be heard in these appeals. 2, the advice by SLC under Article 230, Sub-Article 4B of the Constitution is binding, and that SLC has a role to play in collective bargaining agreement on matters relating to remuneration and benefits of public officers, including teachers. 3, there is unanimity that the order of 14th of January 2014 did not confer jurisdiction to the trial court. There is also unanimity that, as a general principle, a judge of the industrial court has no jurisdiction to conduct conciliation under Section 15 of the Industrial Court Act, as read with Article 159(2) of the Constitution. The majority of the members of the court have made the following findings. There are some minor differences here and there, but the majority of the members of the court have made the following findings. 1, I emphasize the word majority of the members of the court have made the following findings. 1, that SLC also has a role to play in job evaluation of public officers, including teachers. 2, that the judge erred in backdating the award. 3, that the trial judge erred in not taking into consideration the expert evidence of Dr. Geoffrey Moao. And 4, that petition number 3 of 2015 was not compromised. So, for those reasons, the unanimous judgment of the court is that the 3 consolidated appeals, I repeat again, for those reasons, the unanimous judgment of the court is that the 3 consolidated appeals be and are hereby allowed. The judgment of the trial court dated 30th of June 2015, and the decree thereof, and all consequential orders be and are hereby set aside in their entirety, and each party to bear its own cost. The judges will make correction in the judgment, and the judgment will be released on Monday, because it's up past 2 just now. Yes. Yeah.
Hi.
Okay. Yeah. Senior counsel. Yes. Yeah.
Sit down.
Yeah. She's hungry. It's past 2 p.m. Yeah.
My Lord and Your Lordship, I have asked that copies of the Constitution be made available to us on private basis by next week to enable faithful to not the final word. The reason for that is that we are here dealing with a matter of intent of the people. Education in public schools, and the fact that it does not need rocket science to see that demoralized teachers cannot deliver that quality education. So the sooner the Supreme Court adjudicates on this matter, give the final one, if we can have the proceedings next week, we will be great. Thank you.
That's possible. Yeah.
So we make an order.
Yes, of course. In fact, by Friday next week, they should be checked.
Friday is which date? Friday is which date?
13th.
Friday is which date, Mr. Noregi?
13th.
Next Friday. Next Friday.
13th.
13th. Okay.
Where's your quorum sheet? That's why you should make the order.
That's right. Possible to read the judgment by Monday?
Can you write it down?
Yeah?
To have them read.
To correct them and to read them on Monday. Is that possible? We have given them 1 week.
Yeah.
What about judgment by Monday?
That's fine. They should be ready.
This afternoon for Monday. This afternoon. It's going to 3.
No, Monday.
Monday. Okay, this is the order we have recorded. Order of the court, the registrar of the court to supply certified proceedings to the unions on payment of prescribed fees as soon as practicable, preferably on or before the 13th of November 2015. Regarding the judgments, the judges have assured me that it's possible to have them corrected and released by Monday, latest by the afternoon.
We are grateful for
Yeah, okay. So, okay. Thank you very much for...
Mic check 1 2. That particular pay increment. This is news we are receiving from the Supreme Court, where a judge, the 6-judge bench, has actually ruled that there was an error when it came to that particular ruling. Court of Appeal. Okay. News we're just getting in from the Court of Appeal. They have actually ruled that the teachers' case that had been taken up to the courts, that they were to get a pay increment of between 50 to 60% was erroneous, and that the judges have found that the industrial court had no powers to make that particular decision. The judges have also ruled that the SRC had actually made submissions to the court, and it is found that these particular recommendations show that the government was not in a position to cater for that particular increment. This is news you're receiving just in from the Court of Appeal. Of course, a big blow to the teachers who have been anticipating to get that particular increment of about 50 to 60%, which was actually awarded about 2 months ago by the industrial court. And we're seeing judges from the Court of Appeal, they have ruled that that court had no powers, and that particular ruling was erroneous. We have our reporters who are actually at the court who will be updating us regarding this particular developing story. Of course, a lot of teachers who are following this case closely, hoping that the courts would rule in their favor. We're talking about over 200,000 teachers who are actually expecting to benefit from that particular pay increment. The government has been categorical, insisting that they do not have the particular funds when it comes to financing that kind of a pay increment. The SRC is currently conducting an audit where they are trying to get a survey across the teaching fraternity. A lot of reports have also come out saying that majority of the teachers do not actually attend classes, a position that the Kenya National Union of Teachers chairman Wilson Sosion has actually faulted, saying that they have continued to provide basic services to the various students across the country. This news comes in as candidates continue to sit their national examinations, both the Kenya Certificate of Primary Education as well as the Kenya Certificate of Secondary Education. We're yet to get a reaction really from NAT regarding what they think about this ruling. It comes at a time when NAT has been actually calling on teachers to remain standing with them in solidarity regarding the different issues that have come across when it comes to the payment of the teachers. This is not the first time that the teachers have taken this matter before the courts. Back in 1997, also in early 2000, there was a case around teachers demanding for better pay when it comes to their remuneration. This is a story that we continue to follow up for you. In case you're just joining us, the Court of Appeal has actually ruled that the pay increment for teachers of 50 to 60% was erroneous, and they have actually recommended that this particular issue will not be implemented. We could see there the lawyers representing the teachers, led by Paul Muite, a little bit shaken by that particular ruling, hoping that the courts would reconsider their position when it comes to that particular court case. This is a story that we've been following up for you all throughout the day, and finally the verdict is out that the courts have ruled that the industrial court had no jurisdiction when it comes to awarding the increment for the teachers of 50 to 60%. This is news that will get and grip the country, bearing in mind that the teaching fraternity constitutes a significant portion of the country's working population. This, of course, is not good news to the teachers who have been hoping to have their increment in this particular financial year. We are yet to also get a position from the president regarding this story. The president has also been on record saying that they will pay for performance, and the teachers have actually also fronted their case, saying that they have been delivering on their part and they have not been getting the required compensation when it comes to this particular issue around their payment, when it comes to their salaries. And just a quick recap of that story is that the Court of Appeal has thrashed the verdict that was issued by the Industrial Court that sought to award teachers a pay increment of between 50 to 60%, and the courts have recommended that that particular matter be shelved. Other than that, the judges have also ruled by majority that the Industrial Court made an error against what the Salaries and Remunerations Commission had mentioned. I'm now told we have the Secretary General of the Kenya National Union of Teachers, Mr. Wilson Sosion, who will be giving us his feedback regarding this. Well, pictures coming to you on the screen there are the Secretary General of the Kenya National Union of Teachers, Wilson Sosion, just reacting to the ruling that has been issued by the Court of Appeal. He is flanked there by other union officials. They look quite a bit surprised by this particular ruling. They have been hoping to get a favorable ruling regarding this particular matter that has dominated the headlines across the month. We now have his audio there.
They remain the only windows of opportunities to guarantee justice to the citizens of this country. And I think Mr. National Chairman will leave it at that.
Thank you. National Chairman. National Chairman.
Oh, thank you. Precisely, I can do it from here. Precisely, let me welcome my Secretary General to give you a brief statement, but I want to thank the teachers of Kenya for the patience, and you in particular for what you have taken us through. But what we have seen shows that the rule of law and the judicial system is dying out, but we shall be giving you more information next week. May I allow the Secretary General to give you a small word for now.
Thank you so much, the members of the press. I think what you have observed, let me say that we are grateful for the support that the media has extended to the teaching fraternity in this country, and we also appreciate the general public who have been with us in this. But one thing which we must confess, that as much as we are going to consult, it appears that the labor movement is under siege, and our right to collectively bargain is compromised by this judgment, and that one sends a message of disaster, that we are losing the courts, because even Parliament has abandoned its obligation to be a serious watchdog. So let us watch this space next week. We are not taking it lying low. This is a disaster, and we cannot allow it to happen to our teachers, because teachers are not second-rate citizens. The government cannot operate having been created by the law and then expect us also creations of the law also take it lying low. So allow us to consult and then come back to you when it's appropriate. As my colleague has said, we are headed to the Supreme Court. That one is without doubt. That is a fact. Thank you.
As you're giving us time to give it.
I've said we are not giving further information. Let us just say.
Clarify one question. As much as you're saying you're going to consult, did the union officials foresee what has been given today?
You realize that there was even an application for this current bench which has delivered this judgment to disqualify itself. So this one was foreseen, and we did not have any doubt that the judgment would go the way it has gone. And you have seen that they have followed the real script, that the two lady judges were reading the same thing, and then they pretend that they were reading separate judgments. And you can see that that one is an indication that there is more to this judgment than what is there. So
but you are very well represented by senior lawyers.
We were represented by senior lawyers, and those are the ones who have indicated to us that we need to consult further so that we take the matter to the next level.
Should students in the country have a
that one should not be a subject of speculation at this particular time. Yeah. Thank you.
All right, officials of the giant teachers unions, they are NAT and KUPPET, giving their reactions on the verdict that has been given today by the Court of Appeal. Now, it is quite a sad day for teachers after the Court of Appeal granted that appeal by the Teachers Service Commission seeking to reverse the 50 to 60% salary increment. And so that means that teachers will no longer be awarded that 50 to 60% increment if the verdict by the Court of Appeal is anything to go by. Now, the court argues that Justice Dumanderi of the Labor Relations Court, who gave the teachers the 50 to 60% salary increment, did not have the jurisdiction to handle conciliatory proceedings between the teachers, and so that verdict and that ruling that he gave on June 30th has been declared null and void. So that means the 50 to 60% salary increment has also been declared null and void. It is quite a sad day for teachers. The officials have just spoken to us saying that they have asked for 1 week to extend and consult with their legal counsel, after which they wish to take the matter to the Supreme Court, the highest court on the land, to have the final word. As of now, however, the Court of Appeal has given the verdict that the 50 to 60% salary increment has been reversed. Of course, the court put into submissions the submissions given by both parties during the hearing, which took 1 week to complete. The hearing, which was completed on the 6th of October, both the submissions by the Teachers Service Commission and the submissions by the teachers unions. But the question that remains now is that, is this a lasting solution to the teachers crisis that has been going on? This is not the first of its kind in the country. This has been going on for about 18 years now, and so whether this is a lasting solution will be determined next week as the teachers come back to the Court of Appeal, after which they will take this case to the Supreme Court for a final verdict. For now, we will hand you back to Abby Agina, who is in studio.
Many thanks there, Michelle, updating us on the latest developments coming in from the Court of Appeal, where the judges have actually declared the ruling that was made by the Industrial Court null and void, that would have granted teachers a 50 to 60% pay increment in their desire